What's up, guys? We are back. Fitness Profit Multiplier. Anthony, Jimmy, and Matt from Gym Lawyers today. We're back with a special episode today because we're going to be talking about the legal do's and don'ts in your gym. We're going to give you kind of like a broad overview of what you need to look out for, what you should be doing, shouldn't be doing. So we had to hire a lawyer to come on here today to discuss all these things. So Matt, as much as Jimmy thinks he's the law, you're the law today, my friend.
Hired me. All right, I'll expect my check to come in the mail. Here, I thought I was doing this because I liked you guys.
Oh no, we heard it from the lawyer, Jimmy. Just send the bill to the big guy over
there. All right, let's do some do's and don'ts. Okay, do get everything in writing. We've covered some different topics on some different episodes, and I hope one overarching theme that we've always been covering in every one of the episodes that we've recorded together is why these things need to be in writing. Why we need to be concerned about liability waivers and the contents of those waivers, and why that needs to be in writing, and why we have membership contracts, and why those need to be in writing. Another popular one that we see is third-party services coming in and using the gym space in order to make their own money, whether it be like a physical therapist, a massage therapist, a high school that wants to use the facility because you've got turf and sleds or something like that, and the high school team wants to come and use your stuff. Or a personal trainer. Sometimes we just have like a third-party personal trainer that's like, hey, I'll pay you $300 a month to use your facility. I just want to build my own personal training service. And a lot of gyms do these on handshakes, and we have to tell them, no, you can't just do it on a handshake. You've got to put the stuff in writing. So, a very simple way of doing this is if you are taking money from somebody or you're giving money to somebody, you need to have that agreement put down in writing in some way. Okay, so that's big one, number one. So do put everything in writing. Next, don't assume that just because you've done it in the past or you've been doing it for years that you're good to go and there won't ever be a problem. So, again, we talk a lot with established gym owners about this on this topic of, well, I've had the same general liability waiver since I opened 5 years ago. Why do I need to update my liability waiver? Or, well, I've had the same membership contract for 3 years. What's the point of, it's been working so far, why do I need to update it? All right. And so the laws change, society changes. We need to update these contracts. One that we commonly use in liability waiver is updating the CCTV provisions in your liability waiver, because gyms more and more now have cameras, because that's a popular societal thing to do, and we need to put that stuff in writing. Something else that we suggest that gyms do on a regular basis in order to eliminate a lot of liability is quarterly walkthroughs of your gym. This is something that I've done for years in my gym, and I think I took it for granted that other gyms do it. The more I talk to gyms, the more I realize they don't do it. But as the owner, you're responsible if somebody gets injured in your gym. And if somebody gets injured and they sue you, the first thing you're going to do is pull out their waiver, right? And any savvy attorney who sues you is now going to try to categorize what happened in the gym as what's called gross negligence. And that way they can get around your waiver. And so gross negligence is basically defined as you knew or should have known that there was a potential problem, and yet you did nothing to try to prevent it. Okay. And when we walk through the gym on a regular basis, and we check the bolts on the pull-up rigs, and we check the barbells, and we check the plates, and you check the nylon on the rings, and you look at how the rope is attached up to the ceiling, and you look at all of these things. You look for edges where people can trip. You look for wet spots in your bathrooms. Okay, you can eliminate a lot of potential gross negligence just by going through a walkthrough. Okay.
Really smart idea. I never heard anybody actually talk about that. That's a good idea. And that's something that we talk about the marketing calendar all the time. That's something that you should definitely add on there as one of your tasks to do on a quarterly basis. You think a quarter is enough, or should it be something that's done monthly, to be honest?
Um, I think some things can be done quarterly. Other things should be done monthly. Wet spots in bathrooms and on the floor and other things, those should really be looked at. It's common, or it should be common procedure for your opening and closing coaches to be doing a full walkthrough of the gym. I mean, that's good for just like pick up trash and make sure things are in order, but also let's make sure there's not a big wet spot in the middle of the bathroom. There's classic cases that every law student goes through of, like, the slip and falls, the slip on the banana peels, and we laugh about them, but the question that comes before the court is, was that wet spot in the supermarket long enough that somebody from the supermarket knew or should have known that it was there and took steps to clean it up? So, your noon client coming in and slipping on a puddle in your bathroom and suing you, you can't get away with just saying, I didn't know it was there. Because if you opened up at 5 o'clock in the morning, you had 6 hours to discover that. Presumably you should have known that it was there.
How could that be proven? Just out of curiosity, like, what if something happened in that moment and that person went in the bathroom and no one really saw it? Like, what if that happened at 12? What if the leak happened at 11?
So they would bring in an attorney would bring in other people who were there in the morning, and start asking them if anybody saw the wet spot in the bathroom. If anybody, one of the common issues that you can see in litigation like that is it eventually comes out that somebody actually did tell, like, a coach or another staff member, and they were like, oh yeah, we'll get to it, and then got busy and never did anything about it. So there's different ways of proving that, and it's all specific to each case.
That makes sense.
Okay. Another thing to add to the list here, one of the biggest issues that I hate to hear every week, if you will, is talking to a gym owner, especially about partnerships. And I say, look, you guys need a partnership agreement. We need to go through this. We need to lay all this stuff down. And they say, oh, my partner's my best friend. We won't ever have any issues like that. Okay. Don't ever say that. Don't ever assume that once money gets involved, there won't be any issues, because there are always issues that pop up. Or, I was talking to a woman recently who said, oh, I don't have to worry about that physical touch provision being put in my liability waiver because I am in a very small town and we all know each other, and nobody would ever make a claim that they were touched inappropriately on a tactile cue. So I don't have to worry about that. And the bottom line is, you do have to worry about it. And it's better to worry about it now and get it taken care of than it is to wait until there's actually a problem, because there will be a problem.
Yeah, I agree with that. Better to be safe than sorry.
Yeah. And so I think those are the top ones. I guess I would say another big, like, don't is, now I understand that legal services cost money, and I understand that legal services can be a big chunk of change. I would advise gyms to, don't avoid talking to an attorney just because you think it's going to cost you a lot of money. Because again, as we have a running theme here, it's better to be safe than sorry. And your assumptions aren't always true. So you're really putting your business at risk by not talking to a professional. Really, just general gym owner advice is not talking to a professional regarding any kind of question that you have.
Yeah, I think a lot of gym owners are scared for that reason specifically. Like, oh, it's going to cost so much to talk to a lawyer. Like, especially with contracts. Like, I'm talking to other gym owners about contracts, and I tell them all the time, you should probably have someone look at that. I know, but I don't want to spend the money on it. And I was the same way. I could say that, but it was definitely worth it to do. I've had Matt look at my stuff. I've said this on all the episodes that Matt came on, and it was probably the best money I've ever spent, because it gave me the peace of mind to know, like, all right, it's good. Matt, I had a lawyer look at it. It's good.
Thanks, Anthony. And I think those are the big ones. I think those are the biggest ones that I would share. If you go through that list and you do all the do's and you don't do all of the don'ts, then you'll be good to go.
Yeah, and this wasn't to scare, well, it was kind of to scare you guys a little bit because we want you guys to take action to protect yourself. We talk about on this podcast, and Jimmy and I all the time, profit and freedom. And the only way to have true profit and true freedom is to be able to protect yourself, protect your money, you have to protect the geese that lays the golden egg, so to say. And that's your gym. So doing the quarterly walkthroughs, checking all the bolts. Like really, when was the last time you checked the bolts on the pull-up? And when was the last time you did that? Go through the gym. Even if you're listening to this and you're in the gym, check everything. Check the treadmills, check these things, because these things happen and you don't want to be caught, with something that happens and then have to pay later on.
Mm-hmm.
Jimmy, anything else you want to add to that?
Well, just that if you're a gym owner listening to this and you think the lawyer is going to cost you a lot of money, think about how much time, effort, energy, money, and heartache you are going to experience if you're caught in a situation with your pants down because you didn't have these things in place and you didn't understand the legality of what was actually going through, and you'd rather just fly by night, grab some document online and not ever really have anybody professional look at it. It's an investment, not so this is the salesman in me coming out. It's an investment and not an expense when you really think about it, because you don't even know what could happen in the future if you're getting sued and nothing holds up, right? So got to just do your due diligence on this stuff.
Agreed, man, wholeheartedly. Matt, where can everybody find you?
Yeah, thanks, Anthony. Best way is through our website, gymlawyers.com. It's plural, gymlawyers.com. We have multiple calls to action, forms, everything you can fill out on the website in order to reach out for a free consultation. My cell phone's on there. You can shoot me a text. You can call me. Email address is on there. Everything's there. We're not going to hide from you. And we don't charge just to reach out and start asking some questions. So we encourage everybody, even if it's just something so small as, do I need to have my contract reviewed? There's always some legal issue that I discover or some bit of legal exposure that's outside of what the gym owner currently knows about. And so we just advise, just reach out. It's not going to cost you anything just to talk to us.
Yeah, guys, take Matt up on that. And until next time, we're going to put those links in the description for you guys, Anthony, Jimmy, and Matt, and we'll catch you guys on the next one.